Thank you. Yes, Mr. Little.
Thank you, my lady and my lords. As you know, I appear on behalf of His Majesty's Solicitor General on this reference, Mr. Bentley, King's Counsel,
Yes.
for the offender. Also, as the court knows, this is an application to refer the sentence imposed by Mrs. Justice Chima Grubb on the offender in March of this year. The facts are set out in the usual way in the final reference, and I'm not going to go to them other than on occasions to refer during the course of submissions to matters which we submit are relevant, but those facts are agreed. But what the facts reveal we submit is a case which on any view was exceptional, even in the context of a murder. That adjective is properly used here, as would be the adverb as well, for exceptionally high seriousness. I accept, of course, that I have to get further than that, and I will develop that submission in a moment. But this reference turns on a single issue. There's no issue of course taken with the minimum term, and it can be articulated in this way: was the judge wrong not to impose a whole life order? Or put another way, was such a sentence the only sentence reasonably open to her on the facts of this very unusual case? I accept...
Just so you know this, Mr. Little, as does Mr. Bentley, but for the benefit of the public, we've obviously read the papers very carefully, so we are happy for you simply to refer to the facts as and when they arise.
Thank you.
So far as relevant, but to assure everyone, including you, Mr. Bentley, that we have read all the facts carefully and all the papers. We're also familiar with the authorities. It is clear, as you rightly say, Mr. Little, the judge herself found that the case was of exceptionally high seriousness as a starting point and would have merited a whole life order had the offender been over 21 or over. So really the only issue is whether or not the enhanced exceptionality test was met.
Quite.
And in that context, before you develop your helpful submissions, we have not been able to find any other report or case where Section 3213C has been before the full court. Has there been a case? We're making inquiries of the office as well, but we're not aware. No.
No, not so far as we're aware either.
No, all right. Well, that's helpful. If anybody can contradict that information, they should do so, but that is our present understanding. Thank you.
Thank you. And can I make these matters clear to the extent that they're concessions, but obviously it's a high bar that I have to cross, not only because of the threshold, but because it is clear that the judge considered the matter very carefully. The sentencing remarks are detailed, they're carefully crafted, and she was plainly concerned whether to make a whole life order or not. Hence,
so
she
as
asked...
we see it, so written sentencing notes on both sides below, and of course, Mr. Little, you did not appear below. No. Mr. Cray, King's Counsel, your predecessor, did, and he, in his full written notes, states in terms the enhanced exceptionality test is not met. The judge then appears to have asked for further explicit written submissions on that point, and right. Mr. Cray maintained his original position, and obviously you maintained yours when pressed for those further submissions.
Yes, you've got, I think you've had access to both those notes.
We have. Thank you. Yes.
And in that context, I would make this submission that she was right to be concerned about that issue. I'll come to one of the Stewart decisions, if I can call it that, in a moment, hopefully relatively briefly. But can I just make this point, which I don't say is of real significance, but it does have a relevance in a reference, which is this, that this was not a case following a trial.
No.
This was not a case in which the judge had the case throughout, but I don't overplay that submission.
No, because it was a two-day sentencing hearing.
Absolutely. I simply make the point that this court does have access to really pretty much everything that she had.
Yes.
And you are, in many ways, but not entirely, of course, at no discernible disadvantage as far as that's concerned. But I hope that I've made clear that I don't seek to overplay that point, because,
Understood.
of course, this is this is a decision which is primarily entrusted to the sentencing judge at first instance,
Understood.
as the authorities will establish.
Understood.
Just in relation to the position of Prosecution Counsel, if we're right in our submission, then Prosecution Counsel was wrong. That's obviously not an entire answer to the point, because the court will want to consider the reasoning that was set out to the extent that it was by the Crown. But could I just make this point, and again, I don't want to overplay it, but Prosecution Counsel did say in the second note that these were murders which fell into a category without rational explanation. That is a submission that I would say is surprising on the facts. Now
Sorry, I missed that. Where did you say that?
So that's at Prosecution Note 2, T200 is the...
Oh, it was the Crown submission?
Yes, it was the Crown submission. So it's not the judge's position at all. And in fact, the origins of that phrase derive from some of the authorities. But this was not a case in our submission which that phraseology, and obviously the judge had to form a view about Dr. Koyman's report, and she did. And some of the rationale of the Crown is based on a sort of proceeding on a basis that's inconsistent with the way that the judge ultimately went.
You say it did have a rationale, just a very criminal one.
Quite. So if the court needs to consider the position taken by the Crown in any way here, I would submit that that was a surprising way in which to put it on the facts. But put shortly, the position taken by the Crown is not determinative. It's obviously a relevant consideration. But I would submit that on the facts of this case, it probably doesn't, well, it's certainly not determinative, and it doesn't really take matters much further.
It doesn't. Of course it's not determinative. But here, highly experienced prosecution counsel, if we're looking at the test that you've rightly identified you have to meet, it's not determinative. But we've got highly experienced criminal leading counsel,
yes,
being pressed effectively on whether or not his original stance on this point was right, and maintaining it. That is quite striking. It quite very often, as you know very well, the prosecution will be neutral on this, or say the court will have to consider. But he did go out. He did strike out early on this point, didn't he?
Yes, and we would submit in error, because this is a case which in our submission, it was surprising that I'm going to use this phrase in the, and he took it off the table. It's obviously on the table as far as the judge is concerned.
Yes, of course.
But our submission is that was, on the facts of this case, given that, in our submission, it plainly crosses the exceptionally high seriousness test, to make a submission that is in those terms, in our submission is surprising. And I do pray in aid some aspects of the logic and the rationale that is given for that in the note, to the extent that it matters. But our submission is that if we're right,
you're right,
then we're right, and he was wrong. And if we're wrong, then he may have been right, or he may be right, or he was right. So on the facts of this case, because often the Crown may say, well, you have to consider this matter for you, my lady or my lord, that in our submission is surprising on the facts of this case. But that's as high as I want to put it, if I may. Can I then, unless you want me to develop that point in relation to the Crown, can I really turn to the real
just give me the paragraph reference in the written opening note on murder without rationale. Where was that?
Yes, it's paragraph 13, T200.
Thank you.
The prosecution suggests that taken as a whole, these murders fall into the category of killings without rational explanation. And then the evidence...
I'm afraid I'm working hybrid. Opening note for sentence.
So this is the second...
Second note.
Yeah, so this is
Thank
the
you.
second note.
Paragraph 13.
Paragraph 13.
Yes. Right.
And then the second sentence. the evidence suggested at the time of planning and executing the killings, the defendant's mental capacity was affected by the undiagnosed mental health condition he suffers from. Now, the judge proceeds on a different basis as far as culpability is concerned, as far as that's concerned. So, I'd say to the extent that it's relevant, we do say that those two sentences, when viewed either individually or cumulatively, are matters which may cause this court, of course, Mr. Cray is extremely experienced, former senior Treasury counsel, but everyone can make mistakes, and we submit that he did here.
Right.
So can I then turn, if I may, please, to section 3213C, which is the test that the judge had to consider, and the court may only arrive at a whole life order here if the seriousness of the offence or the combination of offences is exceptionally high, even by the standard of offences which would normally result in a whole life order in a case within subsection 3.
And is it right that if it does so consider, it is obliged to impose a whole life order?
Yes, but of course that does require, I accept, very careful consideration.
Yes, but just in terms of the test,
yes,
I think paragraph 19, subparagraph 13 of Stewart says once the test is met, the court is obliged to impose a whole life order.
yes.
So it isn't a, well, it meets the test, but nevertheless I still don't think whole life order.
Quite.
It is whether or not the test is met. The court considers the test is met. Okay, thank you.
And plainly here, there were two matters that are set out in paragraph 2 of Schedule 21, although they of course, they overlap because they are the substantial degree of premeditation or planning in relation to two or more persons, two of whom were children. So it is what I might call a case that had the two linked factors falling within it, which were of real significance here, even before one considers the other relevant matters, which in my submission meant that this case, as it were, fell within and remained within section 3213B. And can I just set those out?
Yes.
It was a murder of 3 people, 2 of whom were children, including an intended rape. I appreciate there's more said about what was intended in the documentation afterwards.
Sorry, including
the intended rape of the sister. Now that did not take place, but it had been intended. The murders were committed one after the other in their own home, heard by neighbours, and each was aware they were being killed by their son or sibling, and one pleaded, that is the brother, for his life. It involved the use of a firearm, which of itself is not something which is required for that substantial planning and premeditation for paragraph 2 of Schedule 21, as well as the use of the knife, particularly in relation to the brother. And most importantly, when considering those matters, it was done as an intended precursor to the long-held intention to kill many young children, aged 4 or 5, with the use of a firearm. And I appreciate that this may be a distinction which may be thought to not make the difference, but it could properly be said that there was more than, if one needs more than, substantial planning and premeditation. If one were to put another word in front of that, it's difficult to see that this did not involve very substantial planning and premeditation, given what the court knows in relation to the particular coloured uniform that was going to be used, the way in which the firearm was procured, and the research that had been undertaken over many months. And it was done in our submission to achieve national and international notoriety. That is extremely unusual in the context even of a paragraph 2 Schedule 21 case. That would normally only apply to the perhaps a terrorist type of murder. And the intended offending can only have been meant to, but would certainly create the risk at least of inspiring others to match it and even outdo it. And articulated in that way, our submission is that the enhanced exceptionality test was satisfied, and that the age and guilty plea did not make this case, and I'm going to use this word advisedly, a borderline or cusp case. As the court knows, that's a phrase that is regularly used in the authorities, borderline, and I will just say something about that at the end. On the face of the judge's sentencing remarks, it doesn't appear that she fell into the error that I've indicated in writing that some judges sometimes do. So we only raise that as a more general point, which is that borderline of what? You need to look at what the test is, but she does articulate.
Yes, well, I think, speaking for myself, I agree. She didn't fall into the trap.
Quite.
I think it's important, as you say, as the Solicitor General suggests, to make it clear that there should never be any gloss on what are the clear words of the statute.
Quite. Absolutely. Yep. And so this is a case in which we do rely on the way in which the judge sets out the circumstances. To a certain extent, I have rephrased them, although the one aspect which is not clearly apparent from the sentencing remarks is the point that we've made about the intended effect and risk of the intended conduct at the school, which is a very unusual aspect of a murder, falling outside, as I've said, a terrorist murder, or someone seeking to do what he had intended to do. And that is a matter which, in our submission, did require consideration here, and would, in our submission, if properly assessed and taken into account, should have led the judge to conclude that she should impose a whole life order. I accept that the judge, of course, was entitled to consider the relevance and effect of the guilty plea, and was entitled to consider with care the age of the offender. And can I take those in turn? Plainly, there can be cases in which the guilty plea may turn a case into a case that does not justify the imposition of a whole life order, and there will be cases in which a guilty plea ultimately makes no difference. That's clear on the authorities set out in Jones, and then also in Stewart in relation to, for example, Wayne Couzens. In relation to age, can I just say this? If this case met, and properly met, the enhanced exceptionality test, then age has already been taken into account. I'm not suggesting that it is then entirely irrelevant from the judge's consideration, but the way we put it was that care must be taken not to double count. But of course, the court has to consider the underlying offending in the context of his age. This was not a case in which it could begin to be said that there was a degree of significant immaturity or anything such as that. The level of the planning and premeditation was quite the opposite. And I suppose, put in this way, our submission is that despite the guilty plea and the age, they, properly assessed, should not have led the judge to conclude that a minimum term was the appropriate sentence in this case. We've set out our submissions in some detail in writing, Milady, and I really sought to identify the reasons why we say that this case does meet that enhanced exceptionality test by trying to distill down the core elements that are the most seriousness of the offending.
I think they put it very clearly. Just on age and guilty plea, would it be fair to say the judge completely ignored the offender's autism. We know that she decided it didn't reduce culpability, but Dr. Koopman's reports do suggest that there is some impact.
Yes.
On the offender's functioning, significant emotional and behavioural difficulties as a result from the age of 16. What do you say about that?
Yeah, well, she plainly did not either take it into account at all or did not give it any significant weight in the balance. And I accept that I can't have my cake and eat it about saying, well, you're in as good a position or nearly in as good a position as she was, and the court will have to assess that. Although I would submit that on these facts and circumstances, that would not properly have justified the judge stepping back from the imposition of a whole life order. But I don't think I could put it in any sort of more detailed or developed way than really that. And I hope that that's a realistic point for me to make, that, as it were, I can't have my cake and eat it about it. If the court concludes that that was another factor to be taken into account, then of course the court's entitled to do that.
Mr. Bentley.
My lady, the court has already indicated that you've obviously looked carefully at all the documentation. You will have seen, therefore, our supplementary respondent's notice. Yes. I don't propose to take you through it unless you particularly...
Was there any debate before the judge, so far as you can recollect, about paragraph 13 of the prosecution's note? I think you said you adopted them as set out.
Yes, I think
how do you explain, or how do you meet the criticism that this was simply wrong? This wasn't a killing without rational explanation.
Well, I think what we urged on the court, first of all, as you'll appreciate, and as the court's already indicated, very experienced prosecuting counsel. There were clearly, as you'd expect, a number of discussions between counsel before documents were prepared to see which areas we agreed on. It's a very sensitive case, and clearly it was appropriate for that to happen. Certainly as far as we were concerned, we did emphasise the ASD aspect of the case. Now,
the what aspect?
The autism,
yep.
ASD, I'm sorry, I'm using shorthand.
No, I understand. I just didn't hear you.
Autistic spectrum disorder. Mm-hmm. That obviously was something that hadn't been picked up, as it were, in advance, been suspected. Although the judge was not persuaded by our argument that, because we took her to the relevant guideline, the fact is that, certainly in what we submitted, was that the way he behaved, i.e. his obsessional focus on these previous killings and so on, and the meticulous research, actually was very much linked to that condition. I think what Koopman was saying was that doesn't explain someone with autistic traits. That doesn't make the person insensitive. It just means that sometimes they have a very narrow focus. So we were never in a position to, as it were, give an explanation or to say what the rationale was. But the context was very important. The context was that here was a young man who clearly had an undiagnosed condition, neurological condition, and that led him down to what I think I described in court as a sort of internet wormhole, where he clearly became obsessed with things. And that doesn't follow that just because someone's obsessed with things that they will then go on to do this kind of crime. And may I say, anything I say is not intended to play down seriousness. But that was certainly our approach, and that's certainly something I think was recognised by the Crown. And although it's not explicitly, and in fact the sentencing judge in a sense said, well, she didn't find that the guideline was relevant in terms of reducing culpability. We would submit that that has to be an important factor in the background. And I think our starting point would be it's very difficult to see how a 49-year sentence in itself, with all this sort of background, can be said to be unduly lenient. But obviously that then requires an analysis of the new section, which I can come to in due course. Now, looking at the section itself, because I think we conceded, and we concede in our note, that had Mr. Prosper been over 21, I think it would have been difficult to argue against the fact that he satisfied the relevant part of Schedule 21. So it really came down to what the new test, as imposed by the relevant part of Section 321, where that takes us. Now, it's been described, and I think it was described as enhanced exceptionality. We would perhaps characterise it as double exceptionality, because the case has to be obviously exceptional to meet the standard for a whole life sentence for someone over 21. What the statute says effectively is that you have to put another level of exceptionality upon that. And that's where we say the judge was quite right in, I was going to say, rejecting the imposition of a whole life order, but in fact that's not the position, because in fact no one was urging it, although she quite understandably was concerned about it, and that's why she asked, I think, for overnight submissions.
I'm not sure double exceptionality works. We want to stay clear of mathematical exercises, but is exceptionally high even by the standard of offences. So it's a single test of exceptionally high, telling us that it's got to be. I sort of know what you mean, but well, I'm just.
Well, I pondered
off the cuff. I think double exceptionality may take one into unnecessary territory.
Well, I pondered that, and when I was writing out some notes last night, I actually wrote down double exceptionality and put it in speech marks, realising that it was.
Well, I mean, it's very interesting. You may be right.
Well, I think that the point I would make is this, and it's really just a logical point, isn't it? That in an ordinary case, to achieve a whole life order, the case has to be exceptional. Mm. So what the amended statute is saying is that, all right, the case has already got to that. So you then have to put another layer of exceptionality on top of that. So I would stand by the submission, because there's no more than that, but this test is effectively double exceptionality. Even moving away from that, and the court obviously will take its own view, but certainly our submission would be that although this case satisfies the criteria under schedule paragraph 2.1 of schedule, also 2.2 of schedule 21. Of course, the judge then went on to look at, although she doesn't say this explicitly, the starting point, of course, even if the case fell into that exceptionally high case, if one then looks at paragraph 3.1i, a murder falling within, so the case can have a 30-year starting point, where it's a murder falling within paragraph 2, subsection 2, committed by an offender who was aged under 21 when the offence was committed. That still stands. So in a sense, so what I say is this, the judge effectively, what she must have done was looked at this, said, well, all right, it's exceptional, but given his age, and given that she didn't find it enhanced exceptional or doubly exceptional, she would then obviously be taken, even if that was her finding, to the fact that if it's someone under 21 and would have satisfied whole life, then the starting point is 30. And we then come to this. Well, there's then an effectively, I'm not very good at the maths, but it's about an 80% uplift to get to 49 years from that starting point. So, assuming, and obviously...
So I'm looking at paragraph 3 of Schedule 21, Which subparagraph?
I'm looking, sorry, it's 3(1) I. And it's set out actually helpfully in Mr. Little's...
3(2), Roman numeral.
Oh, sorry, it's my fault.
No, it's fine.
I'm not reading it properly.
So
I'm in fact getting that, I'm looking at it in Mr. Little's, or in the reference itself at page 10, because it's set out there in page 10. And it's just below the middle of the page. So this is the sort of 30-year starting point. And I don't know if the court has it now. It actually expressly says, well, if it would have been, if the judge even thought it was an exceptionally serious case, if the person's under 21, then that brings it into this particularly high category.
Yes, I see.
It has 30 years. So the point I would make is, having been brought into that category, you don't have to look at the fact that it's not that here's someone that got 35 years or even 40 years. Here's someone that got 49 years. And I have to say, we thought long and hard about whether we should be, as I know as you had in Sharif, as it were, cross applications. I think we took the view, rightly or wrongly, that the court would probably not want to interfere very much with that sentence. But the reality is that with the existing sentence, the earliest date he could actually be considered for parole,
I understand, is when he's 66.
Is in his late 60s.
Yes.
And as the court will know, the dangerousness, and this is perhaps a misconception outside the courts, the dangerousness is covered by the life sentence.
Yes.
And as the court knows, he's not, if he remains considered to be dangerous, he never comes out anyway. So a life sentence is a life sentence.
Right.
The minimum term simply provides a time when it can be reviewed.
Yes.
And I think it's, I know this court won't lose sight of that, but I think perhaps others looking in on this might lose sight of that. This is a life sentence where the earliest point that he could be considered for review is when he'll be nearly 70. And that uplift from...
Well, my calculation is 66. Am I wrong about that?
You may be, I'm calling that nearly 70, I suppose it's all relative.
Well, those of us who are sensitive
it's
about
still,
this thing, I think,
well,
yes.
pension age is now 66, I think, so that's a pension. He would be a pensioner. Can I put it that way? I don't want to lighten things. This is obviously an extremely serious, concerning case. So we submit here that there were factors to be looked at quite rightly. The guilty plea, that was very significant. And of course this court, having, as it were, endorsed the, as it would do, the Stewart position in Sharif, that clearly that is a factor, and an important factor. And I think, as we explained to the court, various psychiatric assessments were being carried out. And that procedure was not actually completed until, I think, the week of the pre-trial review, which was about a week before the trial. And that's why, at that stage, it was then appropriate to enter pleas if pleas were going to be entered. And I think we did address the judge as to why that couldn't happen before, because obviously we were concerned, as were the Crown, as to his mental state.
My understanding is he pleaded guilty when first arraigned.
Yes, he hadn't been arraigned before.
Yes.
Because psychiatric assessments were being carried out.
Understood.
A number of assessments. So, standing back, what we say is this, that the court also, this court, has emphasised, particularly in recent cases, ZA being an example, that what are now perhaps called young adults, 18 to 25, that the courts are now well aware that they should not be treated as mini-adults. There was substantial planning here, but the planning, in fact, began when he was still a child, because the planning had been going on, I think, for some time, or certainly his interest in, I think up to the year before, he was looking into things. So you have someone who was at the very early stages of being a young adult. That's something the court, even if not expressly, was bound to take into account. The other point that I don't think this court will misunderstand, but should be perhaps understood, because certainly I think the police mischaracterised this after the pleas were entered. There was a press conference on the steps of the court. What happened was, and you'll have seen this from the chronology, that Mr. Prosper obviously had formulated a plan which included, after the killings of his own family, going out and potentially committing a horrendous crime at a school. And you know, and particularly this is very much tied in with his rigid thinking, that he, because of the way that transpired, the awful events transpired in his flat, in his home, those plans effectively went out of the window for reasons I think you understand. That was recognised both by the Crown and by the sentencing judge, who described his plans being thwarted. This wasn't a matter of, as it were, he was carrying the gun and was stopped by the police on the way to the school. He had come out of his premises having committed those 3 murders. He had effectively dumped the bag with the shotgun and the cartridges, and was no longer, and you'll have seen his state of mind's very, his intentions are very obvious from what he'd said after his arrest, that as far as he was concerned, that part of the plan going to the school was no longer, I'm sorry to put it in these terms, it was no longer a runner, because...
It's a short submission, it was his own decision to stop.
It was his own decision to stop. And therefore, to elevate this now, thankfully we're not talking about what this might have been, and had we been in that situation, I doubt I'd be making the submissions I am today. But we're not in that situation. And that was covered in a sense by the firearms charge. And it was made very plain to the court that he, and in fact, the court may not have seen this, but on the CCTV, he can be seen sort of ambling along a pavement. A police car is on the other side of the road driving along. And Mr. Prosper actually kind of steps out and waves down the car. That's actually what happens. So it's not a matter of, as it were, the police finding him or chasing him or whatever. And that perhaps indicates that despite the horror of what had happened in the flat, something had changed in his mind, and nothing further was going to happen. He'd been separated from and had voluntarily separated himself from the weapon and from the cartridges that would have been available. So I think, standing back from all this, I know there's a danger of simply repeating the points because the argument starts to become circular in a way. You have a situation here where, on the face of it, as quite fairly and properly conceded by Mr. Little, King's Counsel, the judge looked at pretty well all the relevant factors. We may say, well, she didn't look particularly at the ASD, but that perhaps would be a point more in my favour than the Solicitor General's. So we would submit that this case clearly was very, very serious. We accept that had it been someone over 21...
21 or over.
21 or over, sorry. The whole life order would have been made. However, and we've taken you to the relevant paragraph 3(2)(I), the judge was then, we say quite rightly, saying, well, it doesn't, this test is so high, and there are factors here which allowed her to stand back from that. There's been discussion of this borderline. I know that Mr. Little today has perhaps not been as bold in his submission as he was in writing about the sort of trend for borderline. But the fact that the judge needed to think about that very carefully, obviously all judges will think about these things carefully, but wanted to hear further submissions. And the fact that experienced, obviously you'd expect us to oppose it, but experienced prosecuting counsel, ex-senior Treasury counsel, took that view. In our submission, Mr. Little is being somewhat bold in suggesting that was a mistaken approach. And lady, those are our submissions in response, and we say you should refuse the application.
Understood. Thank you. Mr. Little, anything to come back on?
Can I just come back on the double exceptionality,
Yes.
lest the court was considering...
Yes.
Yes, suggesting that the first point is obviously the clear words of the statutory provision itself. If there is any assistance, enhanced exceptionality is probably about as good as it gets, on the basis that what is required is a consideration and a comparison of the instant facts against those which would ordinarily, for an adult aged 21 or over, justify the imposition applying the correct test of a whole life order. And I would submit that nothing sort of more or less needs to be said than that. Any suggestion of seeking to recharacterize or place some form of formulation such as double or runs the risk of more difficulties than it seeks to solve.
Thank you very much. Thank you. We are, of course, acutely aware of the tragic context in which this reference arises, and aware of the public interest as well as the immediate interest of family and friends. We hope to be able to give a full judgment this morning, but we will need to obviously retire and consider whether we can do that. I think the best thing to do is to release everybody until noon, and we'll come back into court at noon and hopefully be able to proceed then, and if we can't, we'll obviously indicate the way forward.
Thank you very much.
Is there anything else at this stage, any difficulties with that proposed course of action?
No.
So, Mr. Prosper, we've heard the oral submissions from the prosecution and your own leading counsel this morning. Those oral submissions have now completed. We are going to, the three of us, the judges, are going to leave court now for 45 minutes and we're going to consider our ruling, our decision. We think we're going to be able to come back into court at 12 o'clock, that's at noon today, and I see you have an officer with you. When you should be back, please, and we will give our ruling. Thank you. This is an application by His Majesty's Solicitor General under Section 36 of the Criminal Justice Act 1988 for leave to refer the sentences which she regards as unduly lenient. By Section 321 3C of the Sentencing Act 2020, the Court may arrive at a whole life order in the case of an 18 to 20-year-old only if it considers that the seriousness of the offence or the combination of offences is, quote, exceptionally high, unquote, even by the standard of offences which would normally result in a whole life order. This is described in our judgment accurately as an, quote, enhanced exceptionality requirement, end quote. The Solicitor General contends that the seriousness of the offending met the enhanced exceptionality requirement, such that the judge was wrong not to impose a whole life order. This court has not previously had to consider a case involving Section 321 3C of the Sentencing Act 2020. We grant leave. The facts, background and build-up to the offending. The offender's parents separated when he was around 8 years old. He lived with his mother and brother and sister in a flat on the 8th floor of a block of flats in the Marsh Farm area of Luton. He had regular contact with his father, who lived not very far away. There were no concerns about the offender's development or mental health during childhood. However, whilst in the 6th form, the offender became noticeably disinterested in interacting with others, both at home and at college. He seemed overwhelmed by social interaction and was uncooperative in lessons. He resisted assessment or intervention and dropped out of college when asked to leave in March 2023. Not long afterwards, the offender began thinking about and then planning a large-scale shooting in the hope that it would make him notorious. He existed in an online world, choosing little real-life contact with others, apart from attending a gym and working part-time in a supermarket for a few months. He was deeply fascinated by notorious murderers, perpetrators of mass school shootings and rapists. He collected images of a young girl who died in the Sandy Hook school massacre in 2012 and started to plan emulating and indeed outdoing the Sandy Hook attacker. He took photographs of 2 nearby primary schools and over 200 indecent images and videos of children. 19 of these were Category A pictures, depicting the rape of children. He recorded audio files discussing topics such as necrophilia, the young female victim in the Sandy Hook attack, and a computer game called The Walking Dead. On the 13th of September 2023, exactly 1 year before the murders, the offender telephoned St Joseph's Catholic Primary School in Luton to find out the pupils' daily timetable and movements. He carried out reconnaissance at the school and captured images of staff and pupils from the school's website. In a note written after his arrest, he drew a diagram of the early years classroom at the school and wrote alongside it, quote, "Kill all." In April 2024, the offender put together an outfit made up of black and yellow clothing, a yellow bucket hat and shoes with yellow soles. He filmed himself dressed in the outfit, acting out a shooting with a piece of wood in place of a gun. In June 2024, he tried to contact the mother of the young female victim in the Sandy Hook attack using a pseudonym. He looked at numerous images of firearms documentation and details of guns for sale. That summer, he obtained the manifestos of Anders Breivik, who killed 77 people in Norway in 2011, and Christopher Dorner, a former police officer who killed several people in California in 2013. He went on to produce a meticulously forged firearms certificate. The events of September 2024. After one failed attempt, the offender succeeded in acquiring a 12-ball Nico double-barreled shotgun and 100 cartridges for a price of £650 on the 12th of September 2024. The gun and cartridges were delivered to him in the car park of the block of flats where he lived. He spent the rest of that day reading about the impact of shotgun injuries to the neck, the means by which he intended to kill himself after his planned school shooting. He also researched necrophilia, Sarah Everard, and mass shootings. The next day, the 13th of September 2024, at 4:11 a.m., the offender watched extreme animated pornography, and at 4:42 a.m., he looked at images of school massacres, including from the Columbine High School in 1999. Between then and 5:33 a.m., the offender was disturbed by his mother, who knew that something was terribly wrong. Upon realizing that her son had a gun, she struggled with him before he shot her in the head at close range in the hallway. Following that, he placed a novel with the title How to Kill Your Family on her legs. His sister woke up. He fired a shot at her from a distance, grazing the back of her head. She ran to hide in the living room, but he pursued her and fatally shot her in the right eye. His brother tried to seek refuge in the kitchen and protect himself with a knife, but the offender shot him in the chest from a distance. Whilst his brother was still alive and moving, the offender stabbed and slashed him more than 100 times to his head, face, neck, torso, and limbs, whilst the boy pleaded with him not to kill him. Although his brother managed to run into the hallway, the offender fatally shot him in the head. The first 999 call was logged at 5:29 a.m. The police arrived at the flat at 5:50 a.m. to find the 3 deceased. There was blood staining throughout the flat, including handprints in blood, as well as aspirated and spattered blood. Several knives were found blood-stained, and at least one of them apparently bent out of shape. In order to carry out the attacks, the offender would have had to reload the double-barreled shotgun at least twice. He spent the next 2 hours hiding from the police. At 6:22 a.m., he posted a pre-recorded video to Facebook in his shooting uniform, reading a script about the Walking Dead game, in which he said that he intended to shoot his sister in the face. At 7:55 a.m., he emerged from the bushes and raised his arm to a marked police car. He had blood on his hands, clothes, and glasses. He had reloaded his gun with 2 cartridges, but then abandoned it, but he did still have a kitchen knife in his pocket. 33 cartridges and 2 mobile telephones were recovered between the tower block and the school. The offender was arrested. He was cheerful and engaged the officers in conversation, asking if the local schools had been locked down. He later admitted that he had joined a paedophile Twitter group to discuss sexual attraction to children, and the primary purpose in trying to destroy his mobile telephones was to protect his online friends from being arrested for child porn. He was taken to the police station and interviewed. He declined to answer any questions, but later did speak to a mental health nurse. He told her that he had planned for a year to kill 34 people, ending in his own suicide. 30 of them were to be school children, aged 4 or 5. The year before, a plan to rob a gun seller had failed, and so he had taken steps to acquire a firearm by deception, he said. He said that he had intended to carry out the shooting on the 12th of September, but had decided that the 13th sounded better. He had taken a knife with him when buying the shotgun, in case the transaction did not go smoothly, and he said that he had been prepared to kill the gun seller. He said he did not hate his mother or his siblings, and he had had a good life with them. His intention had been to kill them in their sleep and to rape his sister. He'd intended to leave the flat around 8:30 a.m., arrive at St. Joseph's at 9 a.m., go into a class and pretend to rob the teachers. He would then start to shoot the 4-year-olds, continuing in another classroom if necessary, to achieve the target of 30 children. His mother, waking up at 4:50 a.m., had triggered all of this activity early and disrupted his plan. He commented that he wished he had killed more. He pleaded guilty to all of the offences when first arraigned after appropriate psychological assessment. The sentence below. The judge conducted a 2-day sentencing hearing, at the conclusion of which she delivered full written as well as oral sentencing remarks. She proceeded without a pre-sentence report, and we agree that one was unnecessary. She had the benefit of a psychiatric report from Dr. Koopman, K-O-O-Y-M-A-N, dated the 5th of February 2025, who concluded that the offender showed clear symptoms of autism. However, he displayed an emotional lack of empathy for others, which far surpassed that explicable by autism alone. He did not fulfill the criteria for a full diagnosis of psychopathy at that stage, but he did have 2 extremely prominent psychopathic traits: lack of empathy and lack of remorse or guilt. Dr. Koopman concluded the offender was apparently driven by desire to be famous or infamous as a mass murderer, having, it seemed, an obsession with mass killers. It was extremely clear, opined Dr. Koopman, that the offender was not impaired in his understanding of the nature of his conduct or in his ability to exercise self-control. His actions were, from his own perspective, entirely rational, with no emotional connection to his family. He had almost no regard for the life of humans, and since his arrest had been in high spirits. The offences were driven by his lack of empathy for others and his desire to become infamous, not because of any impairment in logic, reasoning, or rational judgment. A short but moving victim personal statement from Raymond Prosper, the offender's father, described the desolation of his family as a loss that would never be healed. He considered himself to have lost not just 1, but 2 sons. At no stage did the prosecution contend that a whole life order was appropriate. Rather, it was said that the prosecution could not identify any additional level of exceptionality beyond the exceptional level of seriousness justifying a whole life order for an offender aged 21 and over. It was submitted by the prosecution that the appropriate starting point was for a minimum term of 30 years. That position was maintained in response to a request by the judge for submissions on the specific point of whether a whole life order was merited, given the offender's planning of a mass school killing, as reflected in his guilty plea to possession of a firearm with intent to endanger life. The defence adopted the prosecution's submissions, emphasising that the offender had abandoned his plan for the school shooting shortly after leaving the home address. In careful and full sentencing remarks, the judge set out the facts and the background, then the relevant sentencing framework, including reference to the parties' submissions and the relevant authorities. She indicated that for an adult offender, aged 21 or over, this was obviously a case where a whole life order would be the normal starting point. She turned then to the enhanced exceptionality requirement. She recorded the explicit joint submission of counsel that a lengthy finite term would be a sufficiently severe penalty, and that this was not such an exceptionally serious case of the utmost gravity where the sentence of last resort had to be imposed on an offender who was 18 at the time and 19 at the time of sentence. She viewed the case as a whole. Although the offender was, quote, indisputably a very dangerous man, the risk to the public, she said, was met by the imposition of a life sentence. She identified 10 specific features of his crimes: very substantial premeditation, 3 murders on the same occasion but committed individually, each victim shot with an illegally held firearm, acting during the hours of darkness on people asleep in their own home, a 13-year-old child shot in her face whilst trying to hide under a table, a 16-year-old child shot in the chest, after which being stabbed with a knife or knives, causing numerous injuries, including a wound that penetrated his lung, before being shot to the head. The brother enduring additional suffering during the attack, in which the offender used at least 2 weapons, each victim suffering the anguish of anticipating or being aware of the deaths of others. The fraudulent acquisition and illegal holding of the firearm taken to a school to endanger the lives and to kill dozens of young children. A murder spree with the sole aim of glorifying the name of the perpetrator in the history of mass killers being the sole motive. The judge bore in mind the definitive sentencing counsel guideline, which assists judges with dealing with offenders with mental or developmental disorders and neurological impairments. She summarised the evidence of Dr. Koeman, concluding that the offender's lack of empathy disinhibited him but did not reduce his culpability or afford mitigation. His cognition and ability to refrain from murder were not diminished. She also referred to the guideline on sentencing children and young people. She did not consider the offender to be immature for someone of his age. She also rejected that the separation of his parents provided any meaningful mitigation. She stated that, although troubled by this shocking case, quote, axiomatically, a case which the judge considers to be on the borderline is not one that cleanly clears the hurdle of enhanced exceptionality, end quote. Having reflected, she stated, she agreed with the parties and would not impose a whole life order. She gave 3 reasons. First, that the offender was thwarted from completing his intentions. Secondly, the prosecution had resulted in guilty pleas. Thirdly, the offender was 18 at the relevant time, quote, at the bottom of the bracket, end quote, for the power provided for in section 321(3)(c, and she could impose a substantial finite term well above the starting point of 30 years. Taking account of the aggravating features, making no deduction for matters which had led her to draw back from making a whole life order, the judge reached the minimum terms that we have set out in the introduction. They were based on a very significant increase from the Schedule 21 starting point of 30 years, with a lead minimum term of 49 years for the offences of murder, with time already spent on remand to be deducted. A prison report produced subsequently for this hearing indicates that the offender's behaviour in custody in detention has been stable, with a good level of conduct, with no adjudications. Some drawings he has produced make reference to the index offences have been found, and he has begun to liaise with the prison in-reach team. The parties' respective submissions. Mr. Little, King's Counsel, who did not appear below, submits that the seriousness of this case passed the enhanced exceptionality requirement and that just punishment required the imposition of a whole life order. He submits that on any view, the facts of this case are exceptional. He recognises the high hurdle that he must overcome, namely to establish that the judge was wrong not to impose a whole life order, that he must establish that the imposition of a whole life order was the only course properly open to her. So far as relevant, it is his position that leading counsel for the prosecution below was wrong to submit that a whole life order was inappropriate. He emphasises that a whole life order for an offender of 21 years or more was, so it is common ground, fully justified. And on the basis of the judge's own findings of fact, including her long list of factors grounding the offender's criminality, the enhanced exceptionality requirement was met. So he emphasises this was a murder of 3 people, including 2 children and an intended rape of the girl. The murders took place one after the other in the victim's own home. They were heard by neighbours. The victims were aware of the identity of their attacker, the involvement of a firearm and a knife, that this was all part of an intended precursor to the killing of multiple 4- and 5-year-old children, again with the use of a firearm. He emphasises the extent, the very substantial nature of the premeditation and planning involved, and the ambition of achieving not only national but also international notoriety, with the risk of inspiring others to act in a similar fashion. In short, the enhanced exceptionality test was fully satisfied. The offender's age and his guilty plea did not make this a borderline case. They were relevant considerations, but the offender was not immature, and neither they nor the medical evidence justified the judge stepping back from the making of a whole life order. In conclusion, Mr. Little refers to what has been described in writing as a developing trend for judges to state that a case is borderline and therefore not to impose a whole life order. He submits that whilst that approach, depending on how it is articulated, may be consistent with the case law, there is a danger in it becoming, without care, a gloss on the statutory approach. For the offender, Mr. Bentley, King's Counsel, accepts readily that a whole life order for an adult aged 21 or over would have been merited, but that fact does not assist us, or did not assist the judge below, on the question of whether or not the enhanced exceptionality test was met. He describes that test, in fact, as being accurately described as a, quote, double exceptionality test. He submits that on the facts, that test was not met. He places significant emphasis on the offender's guilty pleas. Standing back, in summary, his submission is that the judge looked at all relevant factors. This clearly was very serious offending, and whilst a whole life order for an offender aged 21 and over was merited, there were factors here allowing and entitling the judge to stand back and withdraw from imposing a whole life order. The relevant sentencing framework. By Section 1.1 of the Murder, Abolition of Death Penalty Act 1965, an offender convicted of murder must be sentenced to imprisonment for life. But when imposing a life sentence, it is also necessary for the court to make an order under Section 321 of the Sentencing Act 2020, which, by subsection 2, must be a minimum term order, enabling the parole board to consider whether it is no longer necessary for the protection of the public that the offender should be confined after the conclusion of the minimum term, unless the court is required by subsection 3 to make a whole life order. In the case of a whole life order, the early release provisions are not to apply to the offender. In the case of an offender aged 21 or over, when they committed the offence of murder, the court must make a whole life order if, quote, the court is of the opinion that because of the seriousness of 1, the offence, or 2, the combination of the offence and 1 or more offences associated with it, it should not make a minimum term order, end quote. In considering the seriousness of the offence, or a combination of the offence and 1 or more offences associated with it, either for the purposes of determining whether to make a whole life order or determining the minimum term, the court must have regard under section 322(3) of the 2020 Act to the general principles set out in Schedule 21 and any sentencing guidelines relating to offences in general that are relevant to the case and not incompatible with the provisions of Schedule 21. Schedule 21 sets out a series of starting points for the court's determination as to whether to impose a whole life order or a minimum term order, and in the latter case, the length of the minimum term. Paragraph 2 of Schedule 21 provides for the circumstances in which a whole life order is the appropriate starting point. 2.1. If A, the court considers that the seriousness of the offence ... is exceptionally high, and B, the offender was aged 21 or over when the offence was committed, the appropriate starting point is a whole life order. 2. Cases that would normally fall within subparagraph 1A include A, the murder of 2 or more persons, where each murder involves any of the following. 1, a substantial degree of premeditation or planning, ... B.A, the murder of a child, involving a substantial degree of premeditation or planning, where the offence was committed on or after the day on which Section 125 of the Police Crime Sentencing and Courts Act 2022 came into force, end quote. Until the introduction of Section 321(3)(c) of the Sentencing Act 2020 by Section 126 of the Police Crime Sentencing and Courts Act 2022, whole life orders were not available for those under the age of 21. However, for offences committed on or after the 28th of June 2022, the court may now arrive at a whole life order in the case of an 18 to 20-year-old, but only if it considers that the enhanced exceptionality requirement is met. That is to say, that the seriousness of the offence or the combination of offences is exceptionally high, even by the standard of offences which would normally result in a whole life order. Paragraph 3 of Schedule 21 provides for the circumstances in which the starting point for the minimum term is 30 years, namely, cases involving offenders aged 18 or over when the offence is committed, where the court considers the seriousness of the offence to be particularly high. Examples include a murder committed by someone under 21, where the murder would attract a whole life for an offender aged 21 or over at the time of the offence. Paragraphs 7 to 11 of Schedule 21 make provision in respect of aggravating and mitigating factors. Having chosen a starting point, the court should take into account any aggravating or mitigating factors to the extent that it is not allowed for them in its choice of starting point. Detailed consideration of aggravating or mitigating factors may result in a minimum term of any length, whatever the starting point, or in the making of a whole life order. Aggravating factors include a significant degree of planning or premeditation. The principles relating to whole life orders for those aged 21 and over have been considered recently and authoritatively by this court in Crown against Stewart and others, 2022 EWCA Crim 1063, 2022 4 Weekly Law Reports 86. There, Lord Burnett of Malden, Chief Justice, reviewed the statutory provisions and the relevant authorities, summarising the relevant principles at paragraph 19, which we need not repeat. Those same principles are engaged when considering the case of a defendant aged 18 to 21, adjusted to reflect the additional requirement for the enhanced exceptionality test to be met if a whole life order is to be imposed. Analysis. We remind ourselves at the outset that we may only increase a sentence if it is unduly lenient, and not merely because we are of the opinion that the original sentence is less than we would have imposed. A sentence will only be unduly lenient if it falls outside the range of sentences which the judge, applying her mind to all the relevant factors, could reasonably consider appropriate. It will only be unduly lenient where, in the absence of alteration, public confidence or the public perception of the administration of justice would be affected. As identified in Stewart at paragraph 19, a whole life order is a sentence of last resort for cases of the most extreme gravity, reserved for the few exceptionally serious cases where the judge is satisfied that the element of just punishment requires the imposition of a whole life order. The case must be exceptionally serious, even in the context of a case of murder. If the judge is in any doubt as to whether this standard is reached, that, quote, may itself well be, unquote, an indication that a finite minimum term is the appropriate disposal. To be imprisoned for a period of 30 years or more is already a very severe penalty. In the case of a defendant aged between 18 to 21, as here, the enhanced exceptionality test must be met in order for a whole life order to be justified. This is an additional factor that has to be satisfied for the making of a whole life order in the case of a young offender. We consider it unhelpful to place any gloss on what is the clear wording of the statute, namely as follows, colon, quote, it is unhelpful to add any gloss to the words of the statute. What is required is a comparison of the facts of the case involving the young offender with the facts that would justify the imposition of a whole life order on an adult offender. Before turning to the grounds relied upon by the Solicitor General, we make two preliminary observations. First, any concession by the prosecution at first instance is no legal bar to the law officers seeking to contend that the judge's sentence was unduly lenient, as confirmed in Stewart, Crown against Stewart, 2016, EWCA Crim 2238, 2017, 1 Criminal Appeal Report Sentencing at 48. But the prosecution approach may, of course, be relevant to an assessment of whether or not it was unduly lenient not to impose a whole life order. Here it is striking that the prosecution not only did not press for a whole life order, but submitted positively that, quote, this, square brackets, was, close square brackets, not a case where a whole life order should be imposed, end quote. It was acknowledged that a whole life order for an adult with full mental capacity would have been justified. Given, however, the offender's age, capacity, and the enhanced exceptionality requirement, the prosecution's submission before the judge was that the relevant test was not met. Whilst, as she rightly recognised, it was always for the judge to reach her own decision, she was nevertheless entitled to place weight on the clear, reasoned and sustained position taken by experienced prosecution leading counsel to the effect that this was not a case that called for a whole life order. Secondly, and relatedly, whilst there was no trial, the judge did consider whether to make a whole life order with conspicuous care, amongst other things, seeking specific further written submissions on the issue. Absent an error of law or principle, this court should be slow to interfere with her overall assessment of where the correct balance lay between, on the one hand, a whole life order, or, on the other, custody for life with a minimum term of 49 years. Against this background, we turn to the grounds relied upon by the Solicitor General. The primary submission is that if a whole life sentence was not appropriate in this case, the bar for passing one is set too high. As set out above, the bar for passing a whole life term on an adult offender is, and always has been, a very high one, reflected in the fact that there are fewer than 100 prisoners in prison today the subject of a whole life order. It is for the sentencing judge to assess whether a murder or murders fall into the rare category of crime where a whole life order is required. Paragraph 2.2 of Schedule 21 gives assistance as to which crimes might qualify for a whole life order, but the ultimate test is whether the seriousness of the individual offence or the combination of offences is exceptionally high. That hurdle has been set even higher where the offender is aged between 18 and 20 by reason of the enhanced exceptionality requirement. It is now accepted that people do not reach full maturity on their 18th birthday. Indeed, there is evidence to suggest that a majority of men in particular are developing in maturity well beyond their 21st birthday. This has an impact not only on the culpability of offenders of this age, but is also relevant to their ability to develop and change more readily as they mature. The judge clearly recognised that she needed to address the question of whether the enhanced exceptionality threshold had been met, and so whether or not a whole life order should be imposed. She set out her reasons for concluding that it was not appropriate to impose a whole life order. She highlighted the age of the offender. He was 18 at the time of the offending, and we would add, in fact, 17 when the planning first started, and therefore of the youngest age when such a sentence becomes available. This was not to double count, but to contextualise the sentencing exercise within the relevant sentencing regime, where age is a constituent part of the enhanced exceptionality requirement. The offender had also pleaded guilty, again a relevant consideration. Further, the offender had intended to rape his sister and to kill a large number of people in a mass school shooting. He had not put those plans into action, a decision of his own. We consider that the judge would also have been entitled to refer to the offender's diagnosis of autism. Whilst not necessarily reducing culpability, his abnormality of mind had caused significant emotional and behavioural difficulties from the age of 16, according to the evidence of Dr. Koyman. The judge rightly observed that the offender was a dangerous man, but she went on rightly to observe that this was not a factor relevant to her decision whether to pass a whole life order. Dangerousness is catered for by the imposition of a life sentence. It is that part of the sentence which ensures that the offender can, if necessary to protect the public, be detained indefinitely. The whole life or minimum term is imposed solely to reflect proper punishment for the crime. The judge's decision to pass a life sentence with a minimum term of 48 years less days already served was itself a very severe sentence for a 19-year-old. It is a sentence which does not allow anyone even to consider him for release until he is almost 68 years old. It ensures that he spends the rest of his youth and the whole of his middle age in custody. We do not accept the Solicitor General's submission that in reaching her conclusion in the way that she did, the judge was unduly influenced by what did not happen and gave too little weight to what did. She identified the multiple factors that made it appropriate for her to consider the making of a whole life order. She set those factors in context by referring to those factors in the context of age, the guilty plea, and the ultimate result, balancing the factors carefully and reaching the conclusion that she did. The Solicitor General urges us to say that this was not a course properly open to her to take. If a whole life term was not required in this case, she asks rhetorically, when will it be required? It is generally unhelpful to speculate on whether or not a case can properly be described as the worst of its kind, but an obvious answer to that difficult question might be the very circumstances envisaged by the offender here, namely, where a carefully planned mass child shooting has in fact occurred. Finally, we do not consider that the judge's approach supports the notion that there is any developing trend to the effect that whole life orders are not being imposed whenever the sentencing judge considers a case to be borderline. However, for the sake of completeness, we agree with the Solicitor General that it is important that there be no gloss on the statutory test laid down by Parliament. As Stewart makes clear, if the judge is in doubt that the offender must be kept in prison for the rest of their life, that, quote, may itself well, unquote, be an indicator that a whole life order is not appropriate. If that is the case for an adult offender, it is just as, if not more, apposite for a young offender. But it is no more than a potential indicator, and certainly not determinative against the making of a whole life order. Conclusion. These were undoubtedly offences of the utmost gravity, with multiple features incorporating disturbing, recurrent themes around school shootings, such as a young male perpetrator, the selection of distinctive clothing, the recording of messages about the activities, a sexual interest in children, withdrawal into an online world, reference to violent computer games, suicidal intention, and a lack of empathy towards victims. As the judge put it, it was the offender's intention to unleash disaster on the community of Luton with intelligent, calculating, and selfish planning. Had the offender been 21 or over at the time of the offending, a whole life order would undoubtedly have been merited, as the judge indicated. But when extending the availability of a whole life order to those aged 18 to 20, Parliament chose to set what is already a very high threshold for a whole life order for an adult, even higher for young offenders. The judge was entitled to conclude that this enhanced exceptionality test was not met on the facts, in line with both prosecution and defence submissions submitted to her at the time, and to conclude that a whole life order was not required. Appalling though these crimes were, we are not persuaded that anything less than a whole life order was unduly lenient, and the reference will be refused. It is a sentence which requires a youth of 18, as he was at the time of his arrest, to remain in custody until he is in his late 60s, and one which might result in him never being released. Finally, as the courts have stated repeatedly, no sentence can ever reflect the value of lives lost. This court shares and expresses its sympathies for the tragic losses of the lives of Juliana Falcon, Kyle and Giselle Prosper, and sends those condolences to all those affected by the actions of the offender. Little Mr. Bentley, thank you both very much indeed. There will be an approved transcript in the normal way. Are there any outstanding matters that we need to deal with?
No, not so far as I'm concerned, my lady.
Thank you, my lady.
You want to say anything?
Mr. Prosper, the reference has been refused, so your sentence remains the same.
Thank you all.